I'm going to find that you are a complete and utter danger to my society. And there's only one thing that we do. Guess what happens now? I'm entering now magistrate orders for protection on both of those people. And I'm ordering you not to have any contact with either of these people. You violate these conditions, I will have a hearing as to whether I'm going to hold you at no bond. Do you understand?
A man stood in a Texas courtroom with 3 separate domestic violence cases open against him, all involving the same woman, and a judge was about to say something so blunt it would leave the entire room silent. What had this man done that pushed a judge past warnings and into something far more serious? And why did his own words in that courtroom end up proving the very case against him? Stay with this one, because the answer reveals exactly how the system tries, fails, and sometimes finally succeeds at protecting a victim from a man who refused to stop. This is the case of Christian Martinez, a Harris County man already out on bond for assaulting a family member back in April.
You are on bond for an assault of a family member from April, and now you've picked up 2 more assaults of a family member. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
Instead of using that second chance to change his behavior, he picked up 2 more assault charges involving family violence in a single night. His wife, Stephanie Martinez, and her 16-year-old brother were both named as victims. Under Texas law, assault of a family member is treated differently than ordinary assault because the relationship between the abuser and the victim creates a pattern the law is specifically designed to interrupt. Being out on bond means a defendant has been released before trial under specific conditions, and violating those conditions is supposed to carry consequences. Martinez was about to test just how far those consequences could go. Court records described a family celebration at Stephanie's father's house on November 2nd.
One of the complainants and the defendant are married. On November 2nd of 2024, officers were dispatched to an assault at a residential home in Harris County, Texas. Officers met with the complainant, who stated that she and the defendant have been common law spouses for 9 years, and that complainant and defendant were at complainant's father's house having a party. The complainant went to move their car so a guest could leave. The defendant became agitated and left. The complainant caught up with him, and he was laying down on the ground.
Stephanie stepped away to move their car so a guest could leave. That single, ordinary act triggered the entire chain of events that followed. Martinez became agitated. He confronted her outside. He grabbed her by the hair. He struck her across the face with an open palm. When she said it hurt, he reportedly told her, "There's no mark, so there's no proof I hit you."
On the ground. The defendant grabbed the complainant's hair and struck her with an open palm to the face. The defendant stated, "There's no mark, so there's no proof I hit you." The complainant stated she felt pain. Complainant 2 is the brother of complainant 1 and is 16 years old. Complainant 2 stated he saw the defendant cause the scene because of the vehicle being moved and observed the defendant cursing and screaming at complainant 1. Complainant 2 heard screaming and went back outside. The complainant 2 saw his dad holding the
Read
defendant.
that sentence again. A man accused of hitting his wife allegedly tried to argue his way out of it, using the absence of a bruise as his defense, as if pain only counts when it leaves a photograph. Her 16-year-old brother heard the commotion and came outside. He watched their father physically restrain Martinez by the wrist to stop him. Police were called, and Martinez was released at the scene. But instead of walking away, he escalated. He began yelling at the teenager again, then lunged toward the boy's father. The 16-year-old stepped between them to protect his dad.
Yes, complainant 1 is wife, Judge. So complainant 2 saw his dad holding the defendant by the wrist while on the ground. Defendant's parents are called, and the defendant was let go. The defendant began to yell and scream at complainant 2 again, and then lunged at complainant 2's dad. Complainant 2 got in between them, and the defendant struck complainant 2 with a closed fist to the side of his cheek. Complainant 2 struck the defendant once back. Officer stated a reasonable person would feel pain after being struck in the face, so he struck complainant 1 with an
Martinez struck him in the face with a closed fist. The teenager struck back once. According to the responding officer, a reasonable person would feel pain after being hit that way, which is the legal standard prosecutors use to establish that an assault caused bodily injury. Think about that moment for a second. A teenage boy stepped physically between an adult and his own father because he believed no one else would. That is not something the justice system trained him to do. That is something ordinary people do every day when the people meant to protect them are not in the room yet. Maybe you have seen a version of this yourself. A coworker who spoke up when a boss crossed a line others were too afraid to challenge? Someone who absorbed the fallout so somebody else didn't have to. That instinct to step in, even when it costs you, is exactly what this teenager did, and it is exactly what put him directly in harm's way. By the time the case reached the courtroom, there were 3 open assault of a family member cases against the same man, all connected to the same complaining witness and
Complainant
her
in the
family.
first assault, who is that?
Judge, it's Christian Martinez. So there are 2 complainants in the other assault.
This is my wife, Your Honor, Stephanie Martinez.
Do we need your help? You're in enough hot water as it is, Mr. Mancias.
I understand, sir.
So it was the wife, Judge. So there are 2.
So she gets another round, right? The
Yes.
new case is against the same complaining witness.
And
The
there is-
judge
so there
asked
are-
a pointed question that cut through every excuse in the room. What is the one thing I asked you not to do? Martinez's answer was quiet. I understand, Your Honor.
What is the one thing I asked you not to do?
I understand, Your Honor.
Was there no protective order at the time?
But understanding
Uh,
after the fact does not undo 3 separate incidents. This is where the case turned. The judge learned a protective order had already been in place at the time of the new assaults, meaning Martinez had allegedly violated a direct court order designed to keep him away from these exact people. A protective order violation is not treated like an ordinary bond condition breach. It signals to a judge that no paper, no promise, and no prior leniency is enough to change behavior. The judge did not raise his voice.
This is a DVD case, so that's why we're looking it up, Judge. They said that they were having a celebration at the dad's house. So I would imagine, but I can't say.
This was
He did not
initially,
need to. He stated plainly that Martinez was, in his words, a complete and utter danger to that family. Then came the consequence almost no one in that courtroom expected: emergency protective orders for both victims, no contact allowed under any circumstance, and a warning that any further violation could mean a hearing on holding him with no bond at all, meaning no amount of money could buy his release before trial. Here is the question worth sitting with. If a system already knew about a prior assault, already had a protective order in place, and still could not stop a 3rd and 4th alleged act of violence from happening, who actually bears responsibility when the system reacts only after the damage is done? Is it the individual who refused to change, or the process that gave him 3 previous chances to prove he already had? The judge added one more layer few expected. A GPS monitor was ordered so his location could be tracked at all times, along with a strict no alcohol and no drug condition.
I'm also now going to put a GPS monitor on you so I know where you are at all times. And I'm ordering you not to consume alcohol or illegal drugs.
Understood, sir.
You understand? Any more issues, I'm going to make your bond so high you'll have teeth falling out.
Yes, Your Honor.
It was
Goes with
not the
you.
maximum penalty available under the law, and Martinez was not sentenced to prison that day. He walked out of that courtroom still presumed innocent, still awaiting trial, still technically free. That is the frustrating part of due process. The same protection that exists for the innocent also slows down consequences for the guilty until a verdict is actually reached. What this case ultimately shows is that protective orders and bond conditions only work when they are enforced immediately and taken seriously the very first time they are violated, not the 3rd time. Justice is not just about the sentence handed down at the end. It is about whether the system moves fast enough to protect someone before the next incident happens. Tell us in the comments which courtroom case you want broken down next, and if this story affected you, subscribe and share it, because an informed public is the first line of defense the justice system actually has.